Hey guys, this is Christian, and this is the first part of your California Notary Public Educational Course. The title of this course is Functions and Duties of a California Notary Public. This course has been state approved by the California Secretary of State. My educational vendor license is 606092. This is the table of contents. There will be multiple videos in which we explain in detail all of the material here. There is 137 slides total, and this educational course should last about 6 hours, and it will be broken down into multiple videos. All right, let's go ahead and get started with Chapter 1, Obtaining and Managing a Commission. Chapter 1, Part A, Eligibility for Appointment. The California Secretary of State appoints notaries public in California. California Government Code Section 8200. The California Secretary of State may appoint as many notaries public as necessary for the notary public convenience. To be eligible for appointment, a person must be a California resident at the time of appointment, unless appointed to serve on a military or naval reservation, be at least 18 years of age, complete a course of study approved by the California Secretary of State, just like this course that you are taking right now, pass a written proctored closed book examination, and pass a background check. So if you've signed up for this course, I'm hoping that you are a resident of the state of California. And if you currently are not, you at least have to be a resident of the state of California by the time that you send in your application to be a notary public. And you must be at least 18 years of age and complete this course. Section 1, Residence Citizenship Requirement. Except for notaries public appointed to serve on military and naval reservations, a notary public appointed in California must be a resident of California at the time of appointment. Section 2, Age Requirement. All applicants for appointment must be at least 18 years of age. Section 3, Course of Study Requirement. An applicant for a notary public commission must satisfactorily complete a 6-hour course of study that is approved by the California Secretary of State concerning the functions and duties of a California notary public. Once again, that is us. Also, an applicant for a notary public commission who 1. Holds an active notary public commission, and 2. Has satisfactorily completed a 6-hour notary public education course approved by the Secretary of State must satisfactorily complete a 3-hour refresher course approved by the California Secretary of State prior to reappointment as a notary public. An individual whose commission expires before applying for a new commission must take an approved 6-hour notary public education course before they can be appointed for another term as a notary public, even if the individual previously satisfactorily completed an approved 6-hour course. Notaries public who have satisfactorily completed another 6-hour course within 2 years of applying for reappointment as a notary public have satisfied the 3-hour refresher course requirement. Section 4, Examination Requirement. All applicants for appointment must pass a written, proctored, closed book examination prescribed by the California Secretary of State. So we do not administer these exams online or on the website. You must go to a closed book examination that is prescribed by the California Secretary of State. So you will go to a location in your county and take the state exam there physically. As of now, there are no entities which offer the state exam online. Section 5, Background Check Requirements. All applicants must complete background check by submitting fingerprints to the California Department of Justice within 1 year of satisfactorily completing the examination. The Department of Justice will compare the applicant's fingerprints and identify information with California conviction records. The Department of Justice will forward the applicant's fingerprints and other identifying information to the FBI, and both the Department of Justice, DOJ, and FBI will advise the California Secretary of State whether the applicant has a criminal history record anywhere in the United States. An applicant convicted of a disqualifying crime may be denied appointment. A disqualifying crime is any felony or a lesser offense involving moral turpitude, or of a nature incompatible with the duties of a California notary public. So often I get a lot of questions from individuals that have misdemeanors, and they're wondering if they will get approved. Honestly, that is up to the Secretary of State. The DOJ and the FBI will advise them with a background check. However, that is entirely up to them. But from my knowledge, definitely a felony is enough to be disqualified. And if you're a felon, you're just not allowed to be a notary public. However, misdemeanors, that is up for question. But usually if you have a misdemeanor, they're looking for cases like fraud, anything that would basically display that you're a dishonest individual. That's more what they're looking for. So let's go ahead and move on to the Section 6 application. All applicants for appointment must complete the notary public application form prescribed by the California Secretary of State each time they apply for a commission, whether they currently hold a commission as a notary public, a previous commission has expired, or they are applying for the first time. A notary public application form and information regarding the appointment process can be found on the California Secretary of State's website. That is very true. It can be found on the website. You can also find that application on the Resource Center section of our website. Also, we will email you that application as soon as you pass this course's quiz. We will email you a California notary application along with your certificate for completing the course. The California Secretary of State must determine that an applicant possesses the required honesty, credibility, truthfulness, and integrity to fulfill the responsibilities of the office of notary public. An applicant must disclose any arrest for which trial pending and any conviction whether or not the conviction may be a disqualifying conviction. Whether or not the conviction may be a disqualifying conviction, and regardless of where and when the conviction occurred, including any convictions dismissed under California Penal Code Section 1203.4 and 1203.4a. Convictions and arrests for which a trial is pending must be disclosed on a previous application, and including any convictions dismissed under California Penal Code Sections 1203.4 and 1203.4a. Failure to disclose any conviction or arrest for which trial is pending may be substantial and material misstatement or omission on the application and grounds for denial of an application of appointment. Now, that is not a myth. That does happen. If you fail to disclose even something that happened, let's say 7 years ago, 8 years ago, you may believe that, hey, you know what, it happened a long time ago, there's no need for me to disclose it. You have to. They will take that as a sign that you're dishonest. So anything that you can think of, just go ahead and write it in on the application. If you need more room on the application, just go ahead and write it on the back of the page or add an additional page. But you must write anything, even for a trial that is pending, as it says. All right, so other grounds for denying an applicant for appointment are detailed later in this course. The key point to remember is that the application for appointment as a notary public must be complete without any omission or misstatement of required information. Part B, Commission. Section 1, Term of Office. The term of office for a notary public is 4 years, starting with the commencement date stated in the commission issued by the California Secretary of State. This is true whether an appointment is for the first time or whether the person has been issued a previous commission. The critical starting date is the commencement date stated in the commission, rather than the date the commission was issued or mailed by the California Secretary of State, or the date the commission was received by the person in the mail. However, A person cannot serve as a notary public until both their oath of office and bond have been filed with the county clerk, and both must be filed within 30 days of the commencement date of the 4-year term stated in the commission. A notary public commission issued by the California Secretary of State does not take effect unless the oath of office and bond are filed on time with the county clerk. If the 30-day deadline is missed, the commission is invalid. So basically, when you receive your commission in the mail, and that's after you complete the total application process, you complete this course, you take your you fill out the application, you take your exam, do the background check. Once you do all of that and all that goes well, you're actually going to receive a package from the Secretary of State containing your commission. And this commission, it'll say, for example, it commences April 8th, 2018. So from April 8th, 2018, you will have 30 days to go to the county clerks with a bond. Now, this bond, you can purchase it from us online at the resource section of this website. We'll just go ahead and sell you the complete package that you need, $149. You get your journal, you get your stamp, you get your fingerprint pad, and you also get your bond. So with that bond, however, when you receive that from us, you will at that point go to the county clerks and take your oath, and you will also file your mandatory bond, which is for $15,000. So once you do that, immediately you can start notarizing. But until you do that, you are not allowed to notarize. So once you receive that supplies in the mail, go straight to the county clerks, take your oath, file your bond, and you're good to start notarizing. But until then, you are not allowed to notarize. And if you take longer than the 30 days from the date that your commission states that it begins, that commission becomes invalid. So you have 30 days to file that oath and to take that oath and to file that bond. So keep that in mind, but that will come up again. Okay, section 2, geographic jurisdiction. All right, so a notary public's jurisdiction is not limited to the county in which the notary public's oath and bond are filed, but a California notary public cannot perform notarial acts outside of the borders of California. Additionally, a notary public appointed to serve on a military or naval reservation is authorized to act only within the boundaries of the reservation for which he or she is appointed. So as you can see, here's a map of the state of California. If you happen, like, let's say, I don't know the names of any of these counties, but let's say you're along the Nevada border, right? And even here in San Diego, I'm down here in San Diego. I'm only allowed to do notarial acts within the state of California. So it doesn't matter if you're along the border of Nevada. If you're a California notary public, you're only allowed to do notary acts within the state of California. So yeah, I could do business in LA County if I'm from San Diego. I could do business in the Bay Area. I could do business anywhere in California. I just can't do business outside of California. And the reason for that is the journals in which we log our transactions. They have to the state of California manages those, and they have to stay within the California rules. So, and that applies for notaries in Nevada. They can't come into California and create complete notarizations over here. So, and that's the way it works for every state in the United States. So, same for California, same for Nevada. So, very important, stay within your borders. You can leave the county, but you cannot leave the state of California to complete a notarization. All right. Okay. So I think I missed this section here. Additionally, a notary public appointed to serve on a military or naval reservation is authorized to act only within the boundaries of the reservation for which he or she is appointed. I may have repeated that twice. I'm not sure, but let's go ahead and move on. So let's use an example. Maria Mobile's principal place of business is in Truckee, California. Accordingly, Maria filed her oath and bond at the Nevada County Clerks. office in Nevada County, California. Maria often travels to South Lake Tahoe in El Dorado County to perform notarial acts for residents there. Now, Patrick Pressure asked Maria to come to his home in State Line, Nevada, to perform an acknowledgement on a document to be filed in El Dorado County. Maria must refuse to perform the acknowledgement in the state of Nevada. As an alternative, Maria may request that Patrick meet her in South Lake Tahoe, El Dorado County, California, or any other convenient location in California to perform the acknowledgement. A notary public's jurisdiction is not limited to the county in which the notary public's oath and bond are filed, but a California notary public cannot perform notarial acts outside of the borders of California. Additionally, a notary public appointed to serve on a military or naval reservation is authorized to act only within the boundaries of the reservation for which he or she is appointed. All right, let's go to Section 3, Bond. A notary public must obtain a bond from a California admitted surety insurer in the amount of $15,000. The bond must be filed with the county clerk of the county in which the notary public's principal place of business is located. The bond is to provide a limited fund to reimburse members of the public who are damaged by notarial misconduct. Now, don't get this confused. This isn't an insurance for the notary. This bond is to provide a limited fund to reimburse members of the public who are damaged by notarial misconduct. However, the notary public and the surety named on the notary public's official bond are liable in a civil action for all the damages sustained from a notary public's misconduct or neglect. So if you do anything to, mess up, you are liable, and that's when that bond will come into play. So best practices tip: there may be personal liability for the notary public to the surety for the amount paid on the bond as damages, and if the damages exceed the amount of the bond. Therefore, a notary public should consider purchasing errors and omissions insurance, keyword insurance, or some other type of liability insurance to cover damages that may occur in the course of performing their notarial duty. So this is different. This is an insurance that could protect the notary, and that one's not mandatory. The one that is mandatory is the bond, which would reimburse members of the public who are damaged by notarial misconduct. So there is a difference. Remember that: bond, insurance. Bond is a mandatory one. Insurance for the notary is not mandatory. However, it is recommended. Therefore, a notary public should consider purchasing errors and omissions insurance or some other type of liability insurance to cover damages that may occur in the course of performing their notarial duties. A negligent notary public may still be personally liable for damages, costs, and attorney's fees exceeding insurance policy limits for damages not covered by insurance. All right, Section 4, Public Employee Notaries. Public. The California Secretary of State may appoint an employee of a California state, city, or county public agency or public school district to serve as a notary public for and on behalf of that public entity. These notary public employees only may perform notarial acts for and on behalf of their public entity employer. These notary public employees are not authorized to perform notarial acts on their own time. These notary public employees must maintain personal control of their journal. The public entity employer may pay the cost of the notary public's bond and supplies, and any fees collected by the notary public employee must be remitted or turned over to their public entity employer. If the notary public is terminated or resigns, their termination or resignation is treated as a resignation of the notary public's commission as well. So if you're if you're hired by a public agency and you are fired or you quit or you leave that employment, that's also a resignation of your notary public commission as well. So you can't take your notary stamp with you in your notary journal and continue to notarize. You would have to leave that behind. So, on termination or resignation from employment with the public entity, the employee must immediately send a written notice of resignation to the California Secretary of State. That's one. And number two, all notarial records must be delivered to the county clerk within 30 days. Number three, the notary public seal must be defaced or destroyed. So when I say you can't take it with you, I mean you can't continue to do business with it, but obviously that journal has to be turned into the county clerks, and your seal must be destroyed. So those are the items that's what you're going to do with your supplies. And of course, write a written notice to the California Secretary of State. So contents. The California Secretary of State may appoint federal civil service employees to serve as notaries public for military and naval reservations within the state of California. A notary public appointed to serve on a military or naval reservation must be a U.S. citizen but does not have to be a California resident. These notaries public may perform notarial acts only on the reservation for which they were appointed, and they cannot collect fees for any service. These notary public federal civil service employees must maintain personal control of their journal. If the notary public stops being a federal civil service employee, the commanding officer of the military or naval reservation must notify the California Secretary of State of the termination, and the termination is treated as a resignation of the notary public's commission. Again, upon termination or resignation from employment with the military or naval reservation, all notarial records must be delivered to the county clerk within 30 days, and the notary public seal must be defaced or destroyed. Part C. Managing Commissions. Section 1. Filing the oath and bond. A notary public's commission takes effect on the date the notary public files their oath of office and a surety bond in the amount of $15,000 with the county clerk's office. A notary public must file both the oath and bond within 30 days of the commencement date stated in the commission. If the oath and bond are not filed within 30 days of the commencement date, the commission is invalid. There are unfortunately no exceptions. The oath and bond must be filed with the county clerk in the county where the notary public maintains his or her principal place of business. The address entered in the business location portion of the notary public's most recently submitted notary application is the notary public's principal place of business. All right, Chapter 1. A notary public with a new commission is permitted to take and subscribe the oath in front of another notary, as long as the oath is administered in the county where the oath and bond for the commission will be filed. In such a case, the completed oath and bond must be sent by certified mail or any other means of physical delivery that provides a receipt to the county clerk for filing. Best practice tip: the oath of office should be taken and subscribed in person at the county clerk's office to avoid mail and processing delays that may prevent the oath and bond from being filed, but the county clerk's office filed by the county clerk's office within 30 days of the commencement date stated in the commission. When a notary public visits the county clerk's office in person, an authorized employee of the county clerk will administer the oath of office, observe the notary public sign the oath, and file both the oath and the bond the same day. The notary public must present an identification document meeting the requirements of Civil Code Section 1185B3A or B, or Civil Code Section 1185B4A or E as proof of identity. So yeah, I would definitely recommend going down to the county clerk's office. It's just easier. It really doesn't take much. I'm not sure how busy the county clerk's office is in your county, but definitely in San Diego County, we have more than one location where we can go and get this done. And you're in there, you're in and out. You just have to take your bond and just be ready to take your oath. The oath should only take about 1 minute, and you'll be in and out. So it's a lot easier than finding a notary and then mailing your oath. And it's just, that sounds like a mess to me. And I personally don't know any notaries that have done that. So I would just recommend, especially if it's your first time, just go take your oath in person at the county clerks. You'll be in and out, and you'll get it done all in one day, all at one time, and you'll be able to get started right away. So Section 2, address change. California law requires a notary public to notify the California Secretary of State of address changes to ensure that the California Secretary of State and members of the public are able to contact the notary public about notarial acts the notary public performed. Notaries public must notify the California Secretary of State by certified mail or any other means of physical delivery that provides a receipt within 30 days of changing their business or residence address. Willful failure to notify the California Secretary of State of a change of address is punishable as an infraction by a fine of up to $500. So you have to let them know as soon as you move. And like it stated, you have to be able to be located at any time, just in case the California Secretary of State has to contact you to get a hold of your notarial records. And it's actually happened to me before, and I'm sure this is how they found my information. I notarized a document for an individual, maybe I would say like 3 months before they contacted me. So immediately after I notarized this document for this individual, she passed away, and it was a power of attorney. So the California Secretary of State, or actually the attorney, I'm not sure if he got my information from the California Secretary of State, but I'm sure he got it from the website. But I got a letter from the attorney, and that was the part that spooked me out. I'm like, how did he get my information? But of course, the California Secretary of State has all our information on there, and he must have looked me up by my commission number on the stamp, or I'm not sure how, but he found my address, and I received this letter, and on it was an affidavit that I had to complete saying that I did notarize that document for that lady. They just wanted to go ahead and verify. So this is an example of why it's very important for you to have an updated address, because at any time they may need to confirm that notarization did occur, or sometimes they actually need to see a copy of what's in the book. So we're actually going to go ahead and dive into that as well later on. But for now, let's go ahead and go to Chapter 1A, address requirements. An applicant must provide both a business address and a residence address on the notary public application. The notary public applicant may provide a mailing address that is different from their business and residence address. Business address. As part of the business address, a notary public must state the name of the business for which the notary public will perform a majority of their notarial services. Notaries public who will perform services for an employer or at their employer's business location should list the name and address of their employer. If the notary public is not performing a majority of their notarial services for an employer, is not employed or is self-employed, then the Secretary of State's office requests that self or self-employed be entered for the name of business on the application. If there will be no single location where the notary public will perform a majority of their notarial services, the business address will be the location where the notary public performs the greatest number of services, or the address where the notary public receives mail related to their notary public commission. So like, for example, if you're a mobile notary and you don't have an actual office where you're going to be completing the most of your notarial transactions, just go ahead and place your the address where you will receive your notary public related material. So that could be your home. You could write that address in. So something to keep in mind. Not everyone has an office for notary public. So residence address. A notary public may not use a private commercial mailbox or a post office box as an address for his or her residence or principal place of business unless the notary public also provides the California Secretary of State with a physical street address of their principal place of residence. The California Secretary of State must have a record of a notary public's actual residence street address. So there you go. So in case they need to reach you ASAP, they know how to reach you ASAP. And if you leave a P.O. box or a personal mailbox, PMB, they may not be able to reach you just as fast because you may not find that mail for the request for whatever it is the Secretary of State is requesting on time. So it's very important. The address is very important. So a mailing address different from the business and residence address is not required, but may be used if a notary public receives mail at a post office box or a private commercial mailbox. B. Address change procedures. Any change to any of the three addresses inserted in the notary public application or to any previous address change notification must be reported to the California Secretary of State. For example, if a notary public indicated on the application for appointment that the notary public would perform services at the employer's location and the notary public's employment ends for any reason, then the notary public must notify the California Secretary of State of another business address and may state that they are now self or self-employed or provide the name or address of the new employer. If a notary public moves to a new home, then the notary public must notify the Secretary of State of the new residence address. If a notary public chooses to have correspondence sent to a post office box, the notary public cancels the post office contract, then the notary public must notify the California Secretary of State of a new mailing address. So you must let them know. The notification to the California Secretary of State can be by letter or by the change of address form that can be found on the California Secretary of State's website. So I will go ahead and provide that link. This link does not work. You're watching a video, but I will go ahead and provide that link on the resource center page of this website, so you can look that up later. So best practices tip: in addition to the new address, the notification should include the name of the notary public exactly as it appears on the commission number, and whether the address being changed is a business, residence, or mailing address. If the change is to a business address, the notification should state the name of the business that is located at the new address, if that is where the notary public will perform a majority of the notarial services, or that the notary public will be self-employed. There is no fee to submit an address change form or address change letter if the address of a notary public's principal place of business changes from one county to another. Although not required, the notary public may take and file a new oath of office and bond, or may file a new oath of office and a copy of the original bond in the county where the new business address is located. If the notary public decides to make a new filing within 30 days of filing, the notary public must obtain a new official seal that includes the name of the new county where the notary public has relocated. Best practices tip: when a new seal is obtained, the old seal should be defaced or destroyed, since it no longer complies with the statutory requirement to state the county where the oath and bond are filed. And this is always in your best interest to get rid of these stamps. You don't want these stamps laying around. If they come into contact with the wrong person, they could get their hands on them and create some damage for society and for yourself. Name change. If a notary public changes his or her name, then the notary public must complete and send a name change form to the California Secretary of State. The form is available at www.sos.ca.gov/notary. There is no fee charged for updating a notary public's name with the California Secretary of State. The notary public will receive an amended commission from the California Secretary of State with the new name, but the commission number and commission expiration date will remain the same, so that doesn't change. Within 30 days of the date of issuance of the amended commission, the notary public must file a new oath of office and an amendment to the bond with the county clerk of the county in which the principal place of business is located. Section 4. Responding to written requests of the California Secretary of State. A notary public has two separate duties to respond to written requests of the California Secretary of State. The first one is: a notary public must respond by certified mail or any other means of physical delivery that provides a receipt within 30 calendar days of receiving a written request for information from the California Secretary of State relating to official acts performed by the notary public. Number 2, within the time specified in the written request by the California Secretary of State, a notary public must furnish the California Secretary of State certified copies of his or her notarial journal or any portion of the journal that is being requested. Please note that the 30-day time period for request for information does not apply to the requirement to provide certified copies of the notarial journal or portions of the journal. Respond as directed in the request. Section 5. Agreements with private employers. A notary public employed by a private employer may be called upon to provide notarial services as part of his or her employment. The law permits a private employer and an employee who is a notary public to agree that the employer will pay the premiums on the notary public's official surety bond and the cost of any stamps or other supplies required in connection with the appointment as a notary public or for performing notarial duties for the employer. The agreement may provide that fees collected by the notary public for performing notarial acts as part of his or her employment are to be remitted or turned over to the employer for deposit in the fund from which the employee is paid. If the employer and notary public employee have an agreement for the employer to pay bond premiums and costs for performance of notarial duties, the employer may limit the employee to provide notarial services solely to transactions directly associated with the business purpose of the employer during working hours. However, the notary public employee still can perform notarial acts outside of the ordinary course of employment on their own time. A notary public employee is responsible for following California law, regardless of their employer's demands. Performing an improper notarial act could result in civil or criminal liability for the employer and for the notary public employee. So you can't just break the law because your employer told you to, basically. An employer who requests that a notary public perform acts that do not comply with California law should be referred to California Government Code Section 8225, which provides that any person who coerces or in any manner influences a notary public to perform an improper act is guilty of a misdemeanor. So if you ever have an employer that tries to convince you to do something fraudulent, go ahead and refer them over to Code Section 8225. And they will be able to see that they could be guilty of a misdemeanor if they influence you to do anything illegal. So let's use an example. Perry Paralegal is employed by a California lawyer, Adam Attorney, who is a sole practitioner and specializes in wills, trust, and probate. Adam Attorney requests that Perry Paralegal obtain a notary public commission. So Adam Attorney paid for Perry Paralegal to attend a notary public educational class, aka mynotaryclass.com, and paid for Perry Paralegal's exam and bond. After a commission was issued to Perry Paralegal, Adam Attorney reimbursed Perry Paralegal for the cost of filing his oath and bond and the cost of buying his seal, journal, and a supply of attachable jurat and acknowledgement certificates. Perry Paralegal signed a written agreement to perform notary public services during regular office hours only at Adam Attorney's direction, to collect fees for all services performed during regular office hours, and to deliver all fees collected for services performed during regular office hours to Adam Attorney's accountant. Perry Paralegal's sister, Sissy, asked Perry Paralegal to come to her house after work to acknowledge an interspousal transfer deed that she signed. Perry Paralegal may perform the acknowledgement after regular office hours, even though Adam Attorney has not directed Perry Paralegal to perform the acknowledgement. Perry Paralegal may also perform the acknowledgement and charge the statutorily permitted fees for his service if he wishes, without delivering the fee to Adam Attorney's accountant. So as you can see, Perry Paralegal is allowed to complete notarizations after his working hours with Adam Attorney. So once he gets out of Adam Attorney's office, he is free to notarize whoever he wants, and he is also free to charge whatever money, the fees that are allowed by the state, or do it for free if he wishes to. So he has that freedom after office hours. So, Chapter 2, Notarial Acts and Procedures.